If you are a green card holder who travels internationally, what I'm about to tell you could determine whether you are allowed back into the United States in 2026 or stopped, questioned, and potentially denied re-entry at the airport. The Department of Homeland Security has now confirmed a major enforcement change that will directly impact how green card holders are treated when they try to come home. This is not a rumor. It's not speculation. It's not something that might happen. DHS has confirmed that under new 2026 immigration rules, green card reentry can be stopped if officers believe you no longer truly live in the United States. And here's the part that's catching people off guard. Many of those at risk are doing nothing illegal, nothing reckless, nothing they haven't done for years. Imagine landing after what you believe was a normal trip. You hand over your passport. The officer scans it. The screen pauses. Then you hear the words, "No green card holder ever expects to hear. Please step aside." In that moment, everything you thought you understood about your status is suddenly uncertain. And before this video ends, you're going to understand exactly why this is happening, who is most at risk, and what you must do now to protect yourself before these rules take full effect. Let me slow this down for a moment because I know what this news triggers emotionally. A green card is not just a document. It represents years of waiting, separation from family, financial sacrifice, and endless paperwork. For many people, it represents safety, stability, and finally belonging somewhere after a long journey. So when you hear phrases like re-entry stopped or denied at the border, your first reaction is fear. Fear of being stuck outside the country. Fear of losing your job, your home, your life in the United States. Fear that the rules changed quietly while you were simply visiting family or handling responsibilities abroad. That fear is valid. And if you're feeling it right now, you're not alone. But this is not a moment for panic. Panic leads to bad decisions. This is a moment for understanding and preparation. Because here's the truth most people are missing. These new rules do not mean you can't travel. They mean that travel is now being judged differently. The margin for error is gone. The flexibility many green card holders relied on for decades is disappearing. And whether you're safe or at risk depends far more on patterns, documentation, and timing than on any single trip. Once you understand how DHS and border officers will evaluate you starting in 2026, you move from fear to control. And that's exactly where this conversation is going next. Hi, I'm Sofia, and I spend every single day tracking U.S. immigration policy, DHS guidance, and how those rules are actually enforced at airports and borders. And I want to be very clear with you right now because clarity matters more than comfort in moments like this. What you're hearing about green card reentry being stopped is not social media exaggeration, and it's not fear-driven speculation. The Department of Homeland Security has officially confirmed a new enforcement framework that changes how Customs and Border Protection officers will evaluate green card holders returning to the United States. This framework begins rolling out in phases starting in early 2026, and it directly affects people who travel internationally, even if they have done so responsibly for years. The reason I'm taking this so seriously is because I've already seen how similar policy shifts play out in real life. On paper, the change may look procedural. At the airport, it feels very different. And if you wait until your next trip to understand it, that's when problems happen. This confirmation didn't come quietly or unofficially. DHS released coordinated policy guidance alongside Customs and Border Protection, outlining stricter standards for determining whether a green card holder has abandoned permanent resident status. Major outlets like Reuters, the Associated Press, and the Wall Street Journal have already reported on it. But most green card holders haven't seen those articles, and even fewer understand what the changes actually mean in practice. At the center of this shift is one concept: intent. Border officers are being instructed to look far more aggressively at whether your travel history shows that the United States is truly your primary home. Not where you have paperwork, not where you say you live, but where your life is actually centered. And that evaluation is no longer flexible. It's structured, data-driven, and increasingly automated. For decades, the system operated with a kind of informal understanding. If you were gone less than a year, you were generally fine. If you had a good explanation for longer trips, officers often used discretion. Family emergencies, temporary work abroad, acknowledgement that life doesn't always fit neatly into timelines. Those factors mattered. That era is ending. Under the 2026 enforcement model, discretion is being replaced with thresholds, ratios, and patterns. Border officers are being trained to treat frequent or extended time abroad not as neutral behavior, but as a potential sign that permanent residence has been abandoned. And this is where many green card holders misunderstand the risk. The danger is not one long trip. The danger is what your travel history looks like when it's added up, analyzed, and compared against your presence in the United States over time. This is why so many people who believe they are completely safe are actually the most vulnerable. They've never overstayed. They've never violated a rule. They've entered and exited the US dozens of times without issue. But past smooth travel does not protect you under a new enforcement system. Starting in 2026, every return to the United States is effectively a review of your entire recent history, not just your last trip. And in the next part of this conversation, I'm going to explain exactly how that review works, including the specific time thresholds that automatically trigger scrutiny, even if you think your travel has been reasonable. Here is the first hard line you need to understand, because it changes everything. Under the 2026 enforcement framework, any green card holder who has been outside the United States for more than 180 consecutive days, roughly 6 months, will be automatically flagged for enhanced scrutiny the moment they try to re-enter. This is no longer discretionary. It is not based on how confident you sound, how polite you are, or how many times you've traveled successfully in the past. The system will flag you before you ever speak to an officer. Once that flag appears, you are sent to secondary inspection. And secondary inspection is not a conversation. It is an examination. Officers will pull your full travel history, review how long you've been gone, how often you leave, and begin assessing whether your actions match the behavior of someone who truly lives in the United States. If they decide the answer is no, you are placed in a position no green card holder wants to be in. You may be asked to voluntarily surrender your green card on the spot, or you may be placed into removal proceedings and required to defend your status before an immigration judge. That decision can happen at the airport after hours of questioning with no prior warning. But here is where many people underestimate the risk, because the 6-month rule is not the most dangerous part of this policy. Even if you have never stayed outside the United States longer than 180 days on a single trip, you can still be flagged. Under the new system, DHS and CBP will use an automated tracking model that looks at your cumulative travel over a rolling 3-year period. It calculates how many total days you were physically present in the United States versus how many days you were abroad. If that calculation shows that you spent less than 50% of your time inside the US over those 3 years, you can be flagged for scrutiny regardless of how short your individual trips were. This is the part that's catching long-term green card holders completely off guard. Frequent family visits, business travel, caring for parents, splitting time between 2 countries, all of that adds up. And once the numbers tip against you, the system treats you as someone who may have abandoned permanent residence, even if that was never your intention. Let me make this very concrete so there's no confusion. Imagine a green card holder who takes several trips each year, none longer than 6 weeks. On their own, those trips feel harmless, but when added together over 3 years, they may total hundreds of days outside the country. Under the old system, this rarely caused problems. Under the new system, those days are counted, compared, and weighed against your U.S. presence. Officers are not just asking, "Did you break a rule?" They are asking, "Does your life look like it's based here?" And they are being instructed to answer that question conservatively. That means the burden has shifted. It is no longer the government needing to prove abandonment. It is you needing to prove continued residence. And if you are not prepared to do that, the risk is very real. This is why the phrase green card reentry stopped is not exaggeration. Entry is no longer automatic. It is conditional on how your recent history appears through the lens of this new enforcement model. In the next part, I'm going to walk you through two real-world examples, one person who passes under these rules and one who doesn't, so you can see exactly how small differences in travel patterns can lead to completely different outcomes at the airport. Let me show you how this plays out in real life, because this is where the rules stop being abstract and start feeling personal. Imagine a green card holder named Maria. She lives in California, works full-time in the United States, pays her U.S. taxes, and has built her life there. But she also has an elderly mother overseas, and over the past 3 years, she's traveled frequently to help care for her. Maria took about 8 international trips, each lasting roughly 6 weeks. When you add them all together, she spent around 336 days outside the United States over a 3-year period and about 760 days inside the country. Under the new system, Maria's travel history would absolutely be reviewed. Her passport would be scanned, her data would be pulled, and her presence ratio would be calculated. But here's the key point. Maria still spent well over half of her time living in the United States. Her home, her job, her finances, and her day-to-day life are clearly based there. Under the 2026 framework, Maria may experience questioning, but she is far more likely to be admitted without serious consequence because her overall pattern still supports permanent residence. Frequent travel alone did not hurt her. What protected her was where her life actually is. Now, contrast that with another green card holder, Carlos. Carlos has lived in the United States for years, but he also operates a business abroad and splits his time between 2 countries. Over the past 3 years, Carlos spent about 600 days outside the United States and only around 496 days inside. Individually, his trips never looked extreme. He rarely stayed abroad longer than a few months at a time. Under the old system, Carlos likely passed through customs again and again without much issue. Under the new system, everything changes. When Carlos attempts to re-enter in 2026, the system calculates his presence ratio and flags him immediately. He is pulled into secondary inspection, where officers begin asking a very specific question. Can he prove that the United States is still his primary home? At that point, explanations are not enough. Intentions are not enough. He has asked for documentation, recent U.S. tax returns, proof of a U.S. address, employment records, utility bills, bank statements, evidence of family ties. If Carlos cannot produce convincing proof on the spot, he risks being told that his actions show abandonment of permanent residence. That decision can happen right there at the airport after hours of questioning, without any prior notice. This is the difference that catches people off guard. Maria and Carlos both traveled frequently. Neither violated a law, neither overstayed a visa. But under the new enforcement model, their outcomes are completely different because the system is no longer evaluating trips in isolation. It is evaluating patterns. And patterns tell a story. If that story suggests that your real life happened somewhere else, even part of the time, border officers are being instructed to challenge your status. This is why simply being careful is no longer enough. You need to be aware of how your travel looks when it's totaled, analyzed, and compared against strict thresholds. In the next part, I'm going to address the questions I'm hearing most often right now, starting with the one almost everyone asks first. Does this mean green card holders can't travel anymore? One of the first questions I hear every single day since this confirmation is, does this mean I can't travel at all anymore? And the answer is no. Travel is not banned. Leaving the United States is not a violation. What has changed is how travel is interpreted. The new rules do not punish green card holders for traveling. They punish patterns that suggest you are not actually living in the United States. That distinction matters more than anything else. Short trips, occasional family visits, even multiple trips in a year can still be perfectly fine if your overall presence shows that America is your true home base. The risk begins when travel starts to replace residence. When months abroad quietly outnumber months in the US, the system no longer sees a traveler. It sees someone who may have moved their life elsewhere, even if that was never your intention. The next question I hear is even more emotional. What if I have a legitimate reason to be abroad for a long time? And this is where many people assume compassion will automatically protect them. Under the new framework, documented emergencies do still matter, but the burden of proof is now entirely on you. Caring for a critically ill parent, attending end-of-life matters, dealing with unavoidable family crises. These situations can be considered, but only if you can prove them. That means medical records, hospital letters, death certificates, legal documents, verbal explanations are no longer enough. Officers are being instructed to rely on evidence, not stories. And while family emergencies are recognized, extended work abroad is far more complicated. Unless your employer is a US-based company and you have formal documentation showing that your assignment was temporary and tied to your US employment, long periods of overseas work can actively harm your case. Many green card holders are surprised to learn that running a business abroad, consulting internationally, or managing overseas operations can be interpreted as evidence that your economic life is no longer centered in the United States. Another question that keeps coming up is what role re-entry permits play under these new rules. Re-entry permits are still valid, and they still allow a green card holder to remain outside the United States for up to 2 years without automatically losing status. But this is a critical shift you need to understand. A re-entry permit is no longer a guarantee of smooth entry. Under the 2026 enforcement model, even re-entry permit holders are subject to scrutiny. When you return, officers can still evaluate whether your overall travel pattern and lifestyle suggest abandonment. The permit may prevent automatic loss, but it does not shield you from questioning or review. Think of it as added protection, not immunity. If your life clearly appears to be elsewhere, a re-entry permit alone may not save you. This is why relying on what used to work is dangerous right now. Many green card holders traveled for years without issue and assume that history will protect them. It won't. The system is changing forward, not backward. And the people who get caught off guard are usually the ones who believe they were doing everything right. In the next part, I'm going to walk you through the exact steps you should be taking right now to protect yourself. Practical, specific actions that can dramatically reduce your risk before these rules are fully enforced. So, what should you be doing right now before these rules fully take effect? The first and most important step is to calculate your travel presence ratio immediately. Do not guess. Do not estimate. Take your passport and look at every entry and exit over the past 3 years. Count the total number of days you were physically outside the United States and compare that to the total number of days you were inside. This number matters more than most people realize. If your presence in the US is close to or below 50%, that is a warning sign, even if you've never had a problem before. If your ratio is borderline, the safest move is often to remain in the United States for a sustained period to rebuild that balance before traveling again. Waiting and hoping the system overlooks you is no longer a strategy. Numbers do not negotiate. The second step is documentation. And this is where preparation separates people who pass through secondary inspection from people who panic. You need to be able to prove, not explain, that your life is centered in the United States. That means keeping organized copies of your most recent U.S. tax returns, ideally for at least the last 3 years. Even if you earn income abroad, filing U.S. taxes consistently is one of the strongest indicators of continued residence. You should also have proof of a U.S. address such as a lease or mortgage, utility bills in your name, bank statements from U.S.-based accounts, employment records, health insurance coverage, vehicle registration, and evidence of immediate family living in the United States. These documents should not be scattered across emails or stored somewhere you can't access while traveling. They should be organized, current, and easy to produce if questioned. When an officer asks where your life is based, this paperwork answers before you ever speak. The third step applies to anyone who knows they will need to be abroad for an extended period. If there is a real possibility that you will be outside the United States for more than 6 months, applying for a re-entry permit in advance can provide an important layer of protection. The application process can take several months, so waiting until the last minute can leave you exposed. While a re-entry permit does not guarantee entry under the new rules, it signals intent and planning, and it can make a critical difference when combined with strong U.S. ties. Think of it as one part of a larger strategy, not a solution on its own. The fourth step is often overlooked, but incredibly important for frequent travelers whose situations are complicated. If your presence ratio is close to the threshold, if you split time between countries, or if you've had extended stays abroad for work or family reasons, consulting with an immigration attorney before your next trip can be a smart move. A qualified attorney can review your travel history, identify red flags, help you strengthen documentation, and advise you on whether travel is advisable at a given moment. This is not about fear, it's about informed timing. The cost of preparation is almost always lower than the cost of defending your status after a problem occurs. The fifth step is mental, but it may be the most important of all. Do not assume that because you have never had an issue before, you won't have one in the future. That assumption is exactly what these new enforcement rules are targeting. The system is no longer built on past behavior. It is built on current patterns. The green card itself has not lost its value, but the expectations attached to it have become stricter. If this breakdown is helping you see your situation more clearly, a quick, lets this information reach other green card holders who may be walking into these changes completely unaware. In the next part, I'm going to share a real-world case that shows exactly how preparation can mean the difference between being admitted and losing everything at the airport. I want to show you how this looks when theory turns into real life, because this is where the importance of preparation becomes undeniable. I recently spoke with a green card holder named Ahmed, who has lived in the United States for over 15 years. During that time, he traveled back and forth freely to visit family abroad and had never once experienced a problem at the airport. Over the past 3 years, however, Ahmed spent extended time overseas caring for his father during a serious illness. When everything was added up, he had spent about 550 days outside the United States and roughly 546 days inside. His presence ratio was just under 50%. On paper, that put him squarely in the danger zone under the new enforcement standards. Even though his reasons for travel were deeply personal and unavoidable, when Ahmed returned to the United States, he was immediately pulled into secondary inspection. For nearly 2 hours, officers questioned him about where he lived, how he supported himself, and why he had been abroad so often. They asked for proof of his ties to the United States, not just explanations. This is where preparation changed everything. Ahmed had copies of his U.S. tax returns, his apartment lease, proof of ongoing employment, and documentation related to his father's medical condition. He didn't need to scramble. He didn't need to guess. He was able to show clearly and calmly that despite his time abroad, his life was still anchored in the United States. He was ultimately allowed to enter. But when he told me about the experience afterward, he said it was the most stressful moment he had faced in 15 years as a green card holder. Nothing about it felt routine. Nothing about it felt forgiving. And he left that airport with a completely different understanding of how fragile re-entry has become. This is the new reality. Officers are no longer approaching these cases with assumptions of good faith. They are trained to verify, to calculate, and to challenge. And the people who walk away safely are not the ones with the best stories. They are the ones with the strongest evidence. I know that hearing this can feel overwhelming. It can feel unfair. It can feel like the rules keep shifting just when you thought you understood them. But it's important to understand this clearly. You are not powerless here. These changes are not secret. They are not sudden. and you still have time to position yourself safely if you act deliberately. What puts green card holders at the greatest risk right now is ignorance, not travel. Millions of people have no idea these enforcement standards are coming. They will take trips assuming the past predicts the future, only to discover too late that the system has moved on without them. The fact that you are listening to this now means you are already ahead of that curve. You're giving yourself the chance to adjust, to document, and to protect what you've worked so hard to build. And that matters because under the 2026 framework, knowledge is no longer just power. Knowledge is protection. In the final part of this video, I want to leave you with exactly how to stay ahead of these changes and where to look for reliable updates as this policy continues to evolve. As we come to the end of this conversation, I want you to take one thing with you and hold on to it clearly. These changes are not designed to trap you, but they will catch anyone who is unprepared. The government is not announcing this at airport gates or explaining it during inspection. The system will simply apply the rules quietly and firmly. That's why staying informed is no longer optional for green card holders who travel. The idea that permanent residence is something you earn once and never have to think about again is outdated. Today, permanent residence is something you actively maintain through your actions, your presence, and your documentation. If you treat it that way, you dramatically reduce your risk. If you ignore it, the consequences can be severe and immediate. I want you to understand this clearly and calmly. You have time. You have options. You have the ability to protect yourself before these rules are fully enforced. Start by knowing your numbers. Strengthen your ties. Document your life in the United States as if one day you may need to prove it, because under this new system, you very well might. And remember, the goal is not to stop living your life or abandon family responsibilities abroad. The goal is to make sure that when your travel history is reviewed, it tells the truth that the United States is still your home. If this explanation helped you understand what's coming and how to prepare, consider sharing it with anyone you know who holds a green card. Most people will not hear about these changes until they're standing in a secondary inspection room, wishing they had known sooner. And if you want to stay ahead as this policy continues to develop, subscribing and turning on notifications ensures you don't miss important updates, clarifications, or court challenges that may affect how these rules are applied. Before I sign off, I need to say this clearly. Everything shared here is for general formational purposes only. It is not legal advice. Immigration law is complex. Enforcement practices can change, and individual circumstances vary widely. What applies to one person may not apply to another. If you have concerns about your specific travel history, presence ratio, or plans to leave the United States for an extended period, you should consult a qualified immigration attorney who can review your situation in detail. Always verify information using official government sources, including DHS and CBP, because policies can evolve and enforcement guidance can shift. You work too hard for your green card to lose it because of a rule change you didn't know about. Staying informed is how you protect your future. My name is Sofia, and this channel exists for one reason: to help you understand the rules before they affect your life. Stay safe, stay prepared, and I'll see you in the next update. ChatGPT can make mistakes. Check important.